Well, to discuss affirmative consent, I am joined by a co-author of the proposed affirmative consent bill, Patricia Faraldo Cabana. She is an attorney and criminal law professor, coming to us from Freiburg in Germany and from Madrid. We have Manuel Cancio Melia. He is a professor in criminal law at the Autonomous University of Madrid. Thanks both so much for joining us. Patricia, let me start with you. Bring us back to how Spain got here. Why was this type of specific definition of consent actually necessary?
Well, it's not exactly that. We don't include a specific definition of consent in our proposal for a new law against sexual violence. We take into account that rape is a crime different from any other, in part because of the elements of the crime, but mostly because of the historical treatment of the crime and its victims. Traditionally, a crime is defined by examining what the offender did and what the intended consequences of the crime were. But rape is different from this standard definition because courts have almost always focused on the victim and only incidentally on the offender. So the issue of the victim's consent is always a key component in a rape prosecution. But if you let me continue, I would say that proving rape in a legal system which is still based on a traditional sexist outlook is not easy for any woman. And in Spain, both substantive laws and the laws of evidence and procedure are unfavorable to women, since they are predicated on the traditional view of male and female sexuality and sexual behavior as basically something different. So some pressure on the part of the man and some pretense of unwillingness on the part of the woman are considered normal preliminaries to sexual intercourse. And
okay.
In Spain...
Can we say that in this law, you don't have to say no necessarily, but you do have to say yes to qualify for affirmative consent, and therefore it is not a rape or an assault?
No.
Okay, then what's the difference between what's on the laws now and what this affirmative consent law changes?
Well, the law in Spain has now a distinction between sexual assault and sexual abuse. Sexual assault needs violence or intimidation, whereas sexual abuse only needs the absence of consent. And we would like to change the meaning of what is absence of consent, in the sense that it's not necessary for the victim to oppose resistance, active resistance, to show that she doesn't consent.
Okay. Let me ask Manuel. I mean, Manuel, do you think this law will work? Is it needed, and can it be practically applied?
Well, I do agree with my colleague Patricia in the fact that new legislation that will treat as one offense of assault cases of intimidation or violence, as aggravated rape, and cases of absent consent will send a good message, especially to men, to consider, to test if there is already, and at this moment, consent being given. So the message is okay, but I think already at this moment, the law as it is has a rulement that embodies that only yes is yes. And the question is how courts appreciate the presence of intimidation or of violence. But this is a thing you can't change just with a regulation. If you have a patriarchal society, if you have a bias that favorizes men, it is just fantasy to think that the new legislation would change that.
Okay, go ahead, Patricia. I saw you had a comment.
Yes, I agree with my colleague that it's not a matter of changing only the law. And in fact, we are not proposing only changes in the criminal code, but also that all actors in the criminal system who deal with rape, for instance, policemen, lawyers, judges, and prosecutors, should be taught about the myths that surround the offense of rape, the myths and stereotypes that influence their decisions in the courtroom. So I think this can be more effective than a mere change in the criminal code. And this is also part of the proposal we have presented last week.
Okay, so key to making these laws work then is training judges and lawyers on how to guide and decide these cases under these new laws, correct, Patricia?
Yes.
Okay, so it's not so much about the law as it is changing the mentality of those even in the justice system itself. Go ahead.
Excuse me. No, I would say it's a matter of changing the mentality, of course, and you are right in this regard. But it's also a matter of changing the law, because the Spanish law, has this distinction between sexual assault and rape and sexual abuse, so that sexual abuse is a crime committed without violence or intimidation and without consent.
Okay.
That means that victims unable to show resistance because they are drunk or drugged or paralyzed out of sheer terror are less protected. Mm-hmm. And we want to change also that. We think they merit the same protection as other victims.
Okay. Manuel, if you have a comment, go ahead, but I'd like to have you include what is at risk here. Is it possible that it's running the risk of actually punishing men by having, I mean, what if they misunderstand signals? Because obviously there's a lot of nuances in sexual communication sometimes, and people sometimes like it that way. They don't want to be particularly clear about giving consent or not. So is there a risk for men in this law?
I wouldn't say that this. I don't think that there is any profound difference between the situation we can have with this regulation. It's only symbolic. And in my opinion, we have already with this distinction law that means only yes is yes. The problem is how is to be this understood by a man? And I don't think that there will be a major change, because at the end, you will have always, even with the new Swedish regulation, for instance, that has a wholesome model who understands that gross rape, aggravated rape, is that one that is committed with violence. Even in this case, you need an independent court to decide how the evidence lies, if it is clear that violence and intimidation existed. And I have to underline that we don't have a particular difficult situation for rape evidence in Spain. Spanish courts said 20 years ago already, the Supreme Court said, you don't need to have any resistance to get a rape judgment. Okay. So the problem is changing the whole society and everything that is related to training, new bias, understanding women. That is everything okay, and endorse it. Of course I do. But if it is to get pressure on an independent court, that wouldn't be compatible with our constitution.
Okay, then, Patricia, I mean, if this is largely symbolic, how much more really needs to be done to make a tangible difference in the treatment of sexual assault under Spanish law?
Well, I think the measures included in our proposal related to education and prevention are much more important than the measures concerning the changes in the criminal code. So it's true, we have to change mentality, and that's not easy only with a change in the criminal code. But the law is It's very, I would say...
But Patricia, let me ask you this then. If these laws had been enacted 2 years ago, would the treatment of the wolf pack case have been different?
I think so.
Manuel, do you think so?
It would be considered sexual assault.
I don't think so.
It would be rape.
Manuel, why don't you think so? So, I mean, that's what's at the core here. That is what prompted these changes and the debates in this law. Thousands of people took to the street. They were so deeply disturbed by the ruling in that case. And yet this new proposal, Manuel, you're saying really wouldn't have changed anything.
I'm convinced of it because with the new system, which I would endorse, the idea of not making this fundamental difference between assault and abuse, I agree with Patricia that this isn't a good signal. But even if we had a regulation where we have different degrees of assault, this is a hard case because it's on the verge of intimidation. I think most of our courts and colleagues would say this was a case under the now enacted law. This is a case of rape because there was intimidation. So the same difficulty we would have in the new regulation because the court would have to decide if in this case there has been intimidation, and hard cases make bad law. So I don't think it would make a difference. I hope that courts have learned from this case.
Okay.
That they have to be even more rested on the fact what is the victim feeling.
Right.
But the problem is the same.
Okay.
And I must underline, on the Spanish law, they got a sentence that they wouldn't get in many other jurisdictions.
Okay, Patricia, quick final words.
Yes, I think the law can mean a fundamental change in that we don't ask violence or intimidation for considering the act a crime of rape, but only the absence of consent in the line of the Istanbul Treaty. So I think that's a fundamental change.
Okay, Patricia Faraldo, Cabana, and Manuel Cancio, Melia, thank you both so much for joining us. Unfortunately, we're out of time for this segment of The Newsmakers. Thank you.